Now we turn to the second part in the chapter, performance of contract under Vietnamese law. In fact, as you know, the performance of contract shall be generally provided under the Vietnamese Civil Code under subsection 2, section 7 of chapter 15, albeit not really comprehensive. It may be due to the fact that the Civil Code only provided the general rule for the performance of the contract, which being treated as a judicial act. Some special contracts are subject to specific reasons. For example, the commercial law governs commercial sale contract or service contract. The construction law governs construction contract. Law on housing governs house rental and sale contract of houses. Or the law on land governs the transfer of land use right, and so on. Such reasons may stem from the fact that public or state interests are said to be protected in some cases, or the bargaining power of contracting party deserves to be considered. Many principles of the free market economy, such as freedom of contract, private autonomy of contractor, duty of good faith, or even the principle of parta sunt servanda, may affect the performance of the contract by the contracting parties. It is so necessary for you to take a brief reminder with the previous knowledge on such matter and try your best to tie those in what we have previously learned. In this part, we would just like to take some time to focus on the performance of a contract under the Vietnamese Civil Code. Now we will take time to make clear performance of contract in which consideration is not required from all parties, and the performance of contract supported by consideration from all parties. With respect to a unilateral contract, the obligor must perform the obligation strictly as agreed. The obligor may only perform the obligation prior to or after the time limit with the consent of the obligee. However, with respect to a bilateral contract, where the parties have agreed on a time limit for the performance of an obligation, each party must perform its obligation when the obligation falls. One party may not postpone performance by reason of the other party not having performed the obligation owed to the first party, except in the following cases. First one, the party which is required to perform its obligation first has the right to postpone the performance of such obligation if the ability of the other party to perform its obligation has substantially decreased such that its obligation is not able to perform as undertaken, until the other party is able to perform its obligation or has security for performance of its obligation. As the party which is required to perform its obligation last has the right to postpone the performance of such obligation when it falls due if the party which were required to perform its obligation first failed to do so when due. In the second case, with respect to a bilateral contract, when one party is unable to perform its obligation due to the fault of the other party, so the first party has the right to demand the other party continue to perform its obligation with respect to the first party, or has the right to cancel the contract and demand compensation for loss and damage. This article can be regarded as providing the excuse for non-performance, that is, one party is unable to perform either wholly or in part because the other party has done something which makes performance in whole or in part impossible. For example, A agrees to perform building work on B's land beginning on a fixed day. if B locks the access to the land and does not allow A entry, B cannot complain that A has failed to begin work. The conduct by B will often amount to non-acute non-performance, either because of an express provision entitled A to access the land or because B's conduct infringed the obligation of good faith and cooperation. It also should consider the possibility that one party interference results only in a partial impediment to performance by the other party. In such cases, it will be necessary to decide the extent to which non-performance was caused by the first party's interference, and that to which it was caused by the other party. And last but not least, where the party have no agreement on which party will perform its obligation first, the party must perform their obligation concurrently. Where obligations are not able to be performed concurrently, the obligation, the performance of which will take longer, shall be performed first. Now, we turn to another important part relating to performance of the contract for the third-party beneficiaries. Normally, the contract is effective only between the parties to the contract. The rate obtained under the contract are the rate impersonal. The parties to a contract may agree on performance for the benefit of a third party. As provided in Article 415 of the Vietnamese Civil Code, where a contract is performed for the benefit of a third person, the third person has the right to demand the obliger personally perform the obligation with respect to such third person. If there is a dispute between the parties to the contract as to the performance of the contract, the third person does not have the right to demand performance until the dispute is resolved. An obligee also has the right to demand the obliger perform a contract for the benefit of a third person. So, it is recognized that a third party who is conferred a right under the contract to which he is not a party may be entitled to enforce such a right, and then the promisor shall be obliged to perform the contract for the benefit of the third party. He is directly liable to the promise for the performance. The definition of the contract for third-party benefit is explicitly provided in Article 402, Clause 5 of the Vietnamese Civil Code, namely that the contract for the benefit of a third party is a contract whereby both parties to the contract have to perform their obligation, and a third party is entitled to receive the benefit rate from the such performance of the obligation. As you know, in order to confer a benefit on a third party, it is required that, first, there is an evidence of a promise between the promisor and the promisee that the former will convey a benefit to a third party, I mean the beneficiary. And second, the effect of the term of the contract is that a benefit will be conveyed to a third party. For more clarification, the acceptance of the benefit by the third party is not considered as a condition for contractual validity. A contract for the benefit of a third party takes effect from the date both parties agree to enter into such contract. And the acceptance of the benefit by the third party who is conferred the right under the contract does not alter the fact that the obligation between the parties is created earlier, that is when the contract is concluded. Acceptance does not mean accepting the performance. It means accepting the benefit that originates from the obligation to be performed. Acceptance of the benefit may be executed orally or in writing, or may be expressed by conduct. That is, when a third party proves that he has relied on the terms of the contract and the promisor is aware of or should be aware of such reliance. Now, we can take this following case as an example to clarify whether an agreement between the promisor and the promisee that the former will convey a benefit to a third party shall take effect or not. A. Contract to have his goods transported by B using the ship of B. Pursuant to the contract for the carriage of goods by sea between A and B, there is also an agreement on the immunity of liability provision in favor of C, whose were hired to unload A's goods as transported by B from the ship once it arrived at the docks. Such exemption of liability as explicitly provided in the carriage contract to protect C. While A's goods are being unloaded from the ship, due to C carelessness, it results damage for such goods, and then it claims C to recover damage for the losses suffered by A. In this case, it's so significant to clarify whether C can rely on the exemption of liability as provided in the contract between A and B. Under Vietnamese civil law, the third-party benefits can be recognized in the form of exemption from liability. In this case, suppose that the contract on carriage between A and B is not a standard form contract. So, the exemption clause added in such contract as being freely agreed on by A and B shall be valid. Hence, C can rely on such exemption and then be released from any liability therefrom. However, it should be emphasized that the third-party enforceable right is only available where there is no dispute between the contracting party. If any dispute between the contracting party arises, the third party is not permitted to seek performance. Another question needs to be clarified is that what happens if the beneficiary rejects the benefit? With respect to a third-party right to waive its benefit, it should be noted that where a third person waives its right to benefit prior to the performance of an obligation by an applier, the applier shall not be required to perform the obligation, but must notify the applyee. The contract shall be deemed to be cancelled, and each party shall return anything it had received from the other party. If a third person waives its right to benefit after the applier has performed the obligation shall be deemed to have been fulfilled, and the applyee, of course, must perform its undertaking with respect to the applier. In such case, benefit arising from the contract shall belong to the party which would be the beneficiary if the contract was not for the benefit of the third person unless otherwise agreed. So, it is evident that if the third party rejects the benefit before the promisor performs his obligation, the promisor is released from the performance. In such a case, the contract is deemed null and void. The promisor has to restore the promisee to his pre-contractual position by giving back what he has received from the promise and vice versa. If the promise to confer a benefit on a third party is one among many obligations contracted between the parties, unless otherwise agreed, the rejection of the benefit by the third party does not affect the remaining obligation owed by the promisor to the promisee. For example, the promisor is obliged to pay the promisee the contract price, but but not the total amount of that. Namely, 80% of such amount shall be paid directly to the premise, and the remaining ones, 20% of the contract price, shall be paid to the third party. Since the third party waives its right to such amount only as far as the obligation to the third party is concerned, in this case, the premises is under no duty to pay 20% of the contract price to the third party, and hence the performance of the contract shall be dropped as of only 80% of the original amount. If the third party retracts the benefit after his premiser has performed his obligation, the premiser is discharged from his obligation upon performance. Since the premiser fulfilled his obligation, the premises in turn has to perform his counter-promise to the premiser. Since the third party ceased to be subject to any benefit arising from the contract, such benefit belongs to the party who should have been the beneficiary if the contract is not performed for the benefit of the third party, unless otherwise agreed between the parties. Last but not least, it needs to discuss more about the amendment or cancellation of contract for benefit of the third person. According to Article 417 of the Civil Code, where a third person has agreed to receive a benefit, the party to the contract may not amend or cancel the contract, even where the contract is yet to be performed, except with the consent of the third person. As generally, party to the contract may at any time modify or terminate contractual terms and conditions by mutual agreement. It may result that such party may also have the right to revoke the term of the contract, which confers the benefit on the third party. It reflects the principle of freedom of contract. However, in order to protect the beneficiary, it's necessary to restrict the right to revoke or modify when the third party has accepted the benefit, even though yet to be given to the third party. Article 417 of the Civil Code provided that when the third party has accepted the benefit, the party can no longer revoke or even modify the terms of the contract without the consent of the third party. For further comment, it may be recognized that the current Vietnamese Civil Code makes no fundamental change to the performance of contract for benefit of the third party, as compared with that of the Civil Code 2005. There still be unresolved legal issue arising from the provision on third-party right. 1e. How to clarify what qualifies a benefit enforceable by a third party within the ambit of Article 402 Clause and Article 415 of the Civil Code, especially where there is still be a concern on distinction between the direct benefit and the incidental benefit. Now, let's consider the following case. Suppose that A leases two adjacent parcels or premises to B and C, knowing that according to the law, the landlord is allowed to restrict the tenant from doing certain business. So A and C agree that if A leases the remaining premise to B, A will restrict B from selling computer equipment, the good at being currently sold by C from his leased property. However, later, A and B agreed that B shall be free to sell computer equipment, and then it causes damage to C. The question is that whether C, at its own discretion, may either elect to sue A or B to recover his damage. In this case, C can sue A to recover damage suffered by C from A's breach of the contract with C, but C cannot sue B because there is no contractual relationship between B and C. Another legal issue may arise where one of the parties may promise that a third party will perform the contract. It should be noted that obligations may not be imposed on third party without their consent, since a contract is only effective between parties to the contract. If the third party fails to perform, the party who undertakes to make a third party perform an obligation shall act as a guarantor, and then shall be applied to the performance of such obligation. In this case, the third party shall not be liable for non-performance. There is a crucial question that if a third party consents to take the rights and obligation under the contract, can the third party become a party to the contract? If so, it needs to clarify whether the third party is entitled to negotiate the terms and conditions of the contract or not. At this point, it's so helpful to tie that in what we mention as the right of the direct action. As mentioned, a contract is only effective between parties to the contract, so the premiser is one who is directly liable for performance of the contract, and the premises may only bring a claim against the premiser. However, if the party enter into an agreement with the third party, then the premises may have such right. In a construction contract, the owner pays the main contractor, and then, in turn, the main contractor pays the subcontractor on fulfilling the performance as agreed. However, the owner also enters into an agreement with the main contractor that if the main contractor fails to pay the subcontractor, the owner may subsequently stop payment to the main contractor and instead pay the subcontractor directly so that the subcontractor can complete the work. If there is a dispute on a contractual performance, the third party may not request the premiser to perform his promise until the dispute is settled. Now, we may take the case of insurance for property as an example. In this case, the insured party has a right of direct action against the insurance company, that is, the premiser to the insurer, for compensation against loss suffered by the insured third party as a result of the violation made by the premises, the insurer. However, being acted as a party to a contract, in response of such claim, the premiser may use the same defenses it would have against the premises, such as force majeure, in his counterclaim. If the defense is accepted by the court, so there is no need for the premiser to pay damage to the third-party beneficiary, since he can prove that non-performance is beyond his control.